Castaneda appearing on behalf of Enterprise Bank.
Morning, and I'll take the appearance for the defendants, Scottsdale Oasis and BlackRock Financial.
Good morning, Judge. Michael Denius, counsel of record for all of the defendants, including Paul Chavez, who is also in the virtual courtroom today.
Morning.
Good morning.
Mr. Rogers, are you appearing for somebody?
Yes, Your Honor. This morning, a couple hours ago, I filed a notice of appearance on behalf of National Holdings, which is a second position lien holder on the BlackRock Financial properties. And we just became aware of this matter yesterday. But we, as a junior lien holder on that portfolio of properties, we wanted to appear as a party in interest as the receivership does impact my client's junior lien rights.
Okay, very well. This is the time set for a 15-minute return hearing on the plaintiff's application for appointment of a receiver. I'm not sure that we're going to need an evidentiary hearing. I don't know if the parties have discussed this, but it appears from the record that this is a fully matured note, so it's in default at this point, and there is a contractual right upon the event of a default to the appointment of a receiver. So let me start with Ms. Sauer. Do you want to address the issues?
Good morning, Your Honor. Yes, I will be addressing the issues today. I just wanted to say that the plaintiff, Enterprise Bank, agrees with Your Honor that there is no need for an evidentiary hearing today. It's the borrower is clearly in default. There's been a maturity default. There's also been outstanding property taxes that are in default on the properties. And the properties have also had HOA foreclosures filed on them. So not only is this a right underneath the loan documents and the uniform statute, but the properties need a receiver in there immediately, and it will prejudice the Enterprise Bank to not have a receiver appointed today.
Okay, Mr. Denius.
Good morning, Your Honor. Yes, the defendant requests an evidentiary hearing. The defendant is entitled to the hearing under the Uniform Act. The allegations in the complaint and then the application for the receivership are basically on 2 points. Is aside from the loan being in default, is number one, that the deed of trust at Section 19 gives them the right to appointment of a receiver. And number two, that under the Uniform Act, and specifically it's 33-2605 subpart B as in boy, that they're entitled to a receivership. However, both the terms of the deed of trust and the Uniform Act do not say shall. They do not hamstring the court and say thou shalt do this or a receivership must be imposed. Both the deed of trust and the Uniform Act say a receivership may be imposed upon the following circumstances. And the discretion of the court remains. Ultimately, a receivership, notwithstanding the statute, notwithstanding the language of the deed of trust, comes down to an equitable remedy. And it requires the court, I believe, to hear the evidence and determine the extent to which a receivership is proper, and also to determine the extent to which a receivership should be imposed. Should it be limited?
Now I looked at Section 19 of the deed of trust, and it does say may, but my reading of that was that it says may because it's the option of the lender whether to seek it or not. But I think a sentence or two after it says that, it says that the right of the lender to obtain the appointment is absolute, I think is the language it uses.
I believe Your Honor still has to construe the terms of the deed of trust consistent with the Uniform Act. If the deed of trust simply allows a fait accompli to say, Judge, you have to give us a receivership and everything we want, then there's no point of the law, there's no point of the Uniform Act. The Uniform Act, which the lender already recognizes in their application is applicable, requires the court to go through an analysis, including such things as the danger to the property, and the threat and so forth. I would also point out here that in this case, the lender is not just seeking a receivership, for example, for the purpose of collecting rents. They are seeking to have a person who is basically a certified fraud examiner, Your Honor, an accountant who's not a real estate broker, who's not employed with a real estate firm, to take over complete possession and management of the property. And that's during the few months leading up to this trustee sale. The trustee sale is currently scheduled for November 6th. So I disagree with that position by the lender. Is it still comes back to the discretion of the court to hear the evidence and determine the extent to which a receivership should be imposed, not just whether and if, but also what type of receivership. Do we need a certified fraud examiner to go through the books, or do we need somebody to simply collect rents? Those are all things that the court still needs to decide. It's not simply something that can be done at a return hearing without giving the defendant the right to present evidence and have a hearing on the issue, which the defendant is entitled to do under the Uniform Act.
What is the evidence going to be that the defendants are presenting?
The evidence will be that there is no threat of harm to the property, number one, that the defendant is in active effort to sell portions of the property in order for the loan to be paid off in parts, and also to refinance portions of a loan. Although we have what seems to be one simple loan in this case, Your Honor, it's actually secured by a high number of separate living units, each of which can be sold separately. This is not just a single apartment building. This is not just a single commercial complex. It is individual single-family homes plus a number of fourplexes. The lender wants you to impose a receiver to basically take away the right of possession of the borrower entirely leading up to the trustee sale. That's going to hamper the ability of the borrower to maintain the property and to also attempt to sell the property. Among other things, the lender is going to want you to impose the power upon the receiver to sell the property as it deems fit. And so it's not simply a matter of collecting rents. It's what they want is a complete gag order, or rather a straitjacket that's going to prevent the borrower from doing anything without any indication of any actual risk of harm or threat to the lender's interest.
Okay. Let me see if Mr. Rogers had anything that he wanted to address.
Yes, Your Honor. And although actual harm may not be my name, that is what I will try to impress upon the court. My client is in second position, secured by a deed of trust on the BlackRock properties, which are 12 properties of this larger portfolio that the first position lender has. My client has also noticed a deed of trust sale due to default, and is in a worse position than the first because not only do we have apparently unpaid HOA fees, unpaid real estate taxes, we have a mature and accruing default interest first. And my client was elated to hear yesterday that the first was moving to appoint a receiver, because probably the only hope my client has of getting paid is if these properties are sold quickly in a controlled environment by a broker who is marketing these properties and is motivated to sell them. A trustee sale by the first position lender would be catastrophic to my client who's in the second position. So we do actively support the relief sought by Enterprise. We would, of course, want an order that mandates a separate accounting for the BlackRock properties and the Oasis properties. We would, of course, want to be looped in on any proposed sales and expenses, and we would want notice of any sales, of course. I know defendant's counsel mentioned the receiver proposed. We don't have a position on the identity of the receiver and have no problem with the proposed receiver. Alternatively, if the court were to appoint a broker, we would support that as well. But we do think it's appropriate for the preservation of our own rights that a receiver be appointed to liquidate these properties and cure the monetary defaults of my client, the first position lender, and protect us against the failure to pay real property taxes, HOA fees, et cetera.
Okay, Ms. Sauer, anything further from the plaintiff?
Yes, Your Honor. I did just want to note that Mr. Denius stated there is no risk of harm at the properties, but there already has been harm for the properties. There's outstanding HOA fees that they've now moved to foreclose on the properties, and there's outstanding property taxes. And since the bank is not in possession of the property and the borrower is still in possession of the property, there could be other issues at the properties that we don't even know about. So that's why a receiver needs to be appointed immediately. Additionally, to follow up Mr. Rogers, and to address our notice of default on our NOD on the property, the trustee sale, that's just an additional remedy that the bank can seek. The receiver is what we'd like to get appointed now, and the receiver would go in, evaluate the properties, determine whether or not they would sell them, and move forward through that process. And also the receiver can hire a broker if that's needed. But we would, at the end of the day, we would just like the receiver appointed immediately. Rents are going to be likely coming due at the beginning of September. There are additional problems on the properties that should be addressed by a receiver, and therefore a receiver should be appointed today. Thank you, Your Honor.
Did you submit a proposed form of order appointing the receiver? I didn't see that with the application.
I have not yet, but I can get that to your chambers today.
Okay. I don't find that an evidentiary hearing is necessary in this case. ARS section 332605B provides that in connection with the foreclosure or other enforcement of a mortgage, the court may appoint a receiver for the mortgage property if, and subparagraph 2, the mortgagor agreed in a signed record to appointment of a receiver on default. That's the case here, and it's undisputed that there is a default. The loan is fully matured. There's no dispute about that, so I'm going to grant the application and appoint a receiver.
Your Honor, may I speak?
No.
No.
No, you may not. You're represented by counsel. So I'm granting the application and directing the plaintiff to lodge a proposed form of order appointing a receiver, and I'll take a look at that. Okay, that will conclude the hearing.
Your Honor, we have a bond needs to be set.
I'll decide the amount of a bond when I get the proposed form of order. If you want to assert what the appropriate amount of bond is, I'll take that into consideration.
Your Honor, I'm not. I think everything that you have heard from plaintiff's counsel and Mr. Rogers are factual assertions that have not been proven in the record. And as far as determining the amount of bond, I think we need a hearing to determine the amount of that bond.
Okay, I've already ruled on the application. I've decided that the appointment of a receiver is appropriate. So the application's granted. I'll take into consideration the amount of the bond when I sign off on the order. That will conclude the hearing. Thank you.
Thank you, Your Honor.